You can do everything right after an accident or loss. You report it quickly, you take photos, you go to the doctor, you answer the calls, and then, little by little, the insurance company starts turning your claim into a maze. The adjuster sounds friendly, but the questions feel oddly specific. Paperwork keeps getting requested one page at a time. Weeks pass. Then comes an offer that barely covers your bills, delivered like they're doing you a favor. If that sounds familiar, you're not imagining it. A lot of people think insurance companies look for the truth and then pay fairly. In the real world, many companies are trained to look for ways to reduce what they pay, delay what they pay, or deny what they can get away with denying. And the worst part is that most of these tactics work because regular people don't know what the game looks like until they're already losing it. In this video, I'm going to show you the tricks and tell you exactly how to protect yourself before your claim gets discounted. I'm a practicing attorney, and a big part of my work involves helping people deal with injury and insurance claims after car wrecks, falls, and other serious losses. I handle these cases every day, which means I see the same patterns over and over again from the insurance side. By the end of this video, you're going to know the 5 most common ways insurance companies try to pay less, how those tactics show up in real life, what mistakes to avoid, and what you should do instead if you want to protect the full value of your claim. The first trick is getting you to say something early that can be used against you later. In plain English, the insurance company wants a clean soundbite before you know the full extent of your injuries, your property damage, or even the facts of what happened. They may say, "We just need your side so we can move things along." That sounds harmless. It isn't always harmless. A recorded statement is not just a conversation, it is evidence, and evidence can be taken out of context. Imagine you're driving home from work. Another car runs a red light, and your neck feels tight but not terrible at first. The next morning, you wake up sore, dizzy, and unable to turn your head. But the day before, when the adjuster called, you said, "I'm okay, just a little shaken up." Later, when your treatment gets more serious, the company points back to that one sentence and acts like your current pain must be exaggerated or unrelated. That's the setup. What most people do wrong is they think honesty alone protects them. Honesty matters, but timing matters too. Right after an accident, you usually do not know the whole picture. You should never guess, never minimize, and never fill in facts you are not sure about just to sound cooperative. In many situations, especially when you're dealing with the other driver's insurance company, you are not required to give a recorded statement on demand. What you should do is report basic facts, get medical attention if you're hurt, and slow the process down enough to understand what you're being asked and why. The second trick is delay, because delay creates pressure. Insurance companies know that your life does not pause while a claim is pending. Your car may be in the shop. Your paycheck may be smaller because you missed work. Your medical bills may be landing in the mailbox while the adjuster keeps saying they are still reviewing the file. That delay is not always random. Sometimes it is strategy. Imagine you need physical therapy, your car payment is still due, and you are borrowing rides to get to work. Every week, the insurance company asks for one more document. First, your medical records. Then, an authorization form, which is permission to dig through records. Then wage information. Then a second review. Then a supervisor review. Then silence. After enough weeks of this, even a low offer can start to look tempting, not because it is fair, but because you are exhausted and need the money now. Here's what most people do wrong. They assume a slow claim is just the normal pace of the system, so they wait passively and hope goodwill will fix it. Meanwhile, deadlines can creep closer, memories can fade, and the company's leverage gets stronger. The law in many states requires insurers to investigate and respond within reasonable timeframes, and some states have rules against unfair claims handling, which means dragging a claim out without a good reason can be improper. Practically speaking, you should document every contact, keep copies of everything you send, follow up in writing, and pay attention to patterns. Delay becomes powerful when it leaves no paper trail. Once the timeline is clear, the tactic is much harder for them to hide. The third trick is making your injury sound smaller than it is, and the fourth trick is making your role in the accident sound bigger than it was. Those two tactics often travel together because both are designed to shrink the claim's value. If they can say you were barely hurt and also partly to blame, they have two different arguments for paying less. Imagine you hurt your back in a crash. You go to urgent care, then your primary doctor, then physical therapy. 3 weeks later, you miss 2 appointments because your child gets sick and you cannot get off work. During that same month, you post a smiling photo from a family barbecue. The insurer may use that gap in that photo to suggest you were not really hurt. Then, on top of that, they may argue you were following too closely or could have reacted faster, even if the other driver clearly caused the crash. Now the company is attacking both your injury and your credibility. What most people do wrong is they treat the claim like a common-sense conversation instead of a documented case. They assume the company will look at the whole story fairly. Often, it won't. The legal reality is that claims are often valued based on records, consistency, and proof. So if you are injured, follow through with treatment as best you can. Tell your doctors exactly what hurts and how it affects your day. And if there is a gap in care, make sure there is an explanation in the records. Also, be smart online and be careful with casual statements at the scene like, "I'm sorry," or "maybe I should have seen them." The law does not run on assumptions. It runs on evidence, fault rules, and documented facts. The fifth trick is offering fast money before the true value of your case is clear, then trying to lock you into that deal before you realize what you gave up. This often comes with paperwork called a release. A release is a document that usually says, once you take the money, the claim is over for good. No second bite. No reopening it because you later learned you needed more treatment. Imagine the adjuster calls and says, "Good news. We can get you a check this week. You are relieved. Rent is due. Your arm still hurts, but maybe it will get better. The amount sounds real because it is more money than you have in your account right now. So you sign. A month later, you learn you have a torn ligament, you need follow-up care, and you are missing more work than you expected. It does not matter. The claim may already be closed. What most people do wrong is they compare the offer to their immediate stress instead of the full legal value of the case. A fair claim is not just about today's bills. It may include future treatment, lost income, pain, limitations, and the effect the injury has on daily life. Once you sign a broad release, that leverage is usually gone. The smart move is to avoid settling until you understand your diagnosis, your expected recovery, and the full categories of damage, which is the legal word for the losses the law may allow you to recover. Most people don't realize that the insurance claim can be damaged long before there is ever a formal denial. The first big mistake is talking too freely because the adjuster sounds kind and reasonable. People fill silence, guess at speed or distance, say they are fine because they do not want to complain, or agree to broad medical authorizations because they think refusing will make them look guilty. That openness can give the company more material to reinterpret later than it ever could have gathered on its own. The second mistake is treating medical care casually. Here's where things go wrong for a lot of honest people. They wait too long to get checked out, they skip follow-up appointments once life gets busy, or they downplay symptoms to doctors because they assume the pain will pass. Later, when the insurance company argues the injury was minor or unrelated, the records are thin, the gaps are obvious, and the person is left trying to explain with memory what should have been documented in real time. The third mistake is settling from stress instead of information. Most people don't realize how often a quick payment is designed to buy certainty for the insurance company, not security for you. If you do not know whether you will need imaging, injections, surgery, more therapy, or extra time off work, then you do not really know the value of the claim. Once the paperwork is signed, regret does not reopen the case. That is why patience, documentation, and advice early in the process can be worth far more than people think. First, get the facts preserved early. Take photos, get witness information, keep the police or incident report number, and save every email, text, estimate, bill, and voicemail connected to the claim. Second, get medical attention promptly if you are hurt, and be accurate about your symptoms. Do not tough it out in silence, and do not minimize what you are feeling. Third, slow down before giving statements or signing forms. If you do not understand why they want something, ask. If the request feels broad or rushed, pause before you agree. The fourth thing most people skip is creating their own timeline. Write down when the accident happened, when symptoms started, who called you, what documents were requested, and what the company said. Fifth, stay consistent. Tell the truth, but do not guess, speculate, or fill in blanks. If you do not know, say you do not know. Sixth, do not evaluate an offer based only on today's pressure. Ask whether you know the full diagnosis, the future treatment picture, the lost wage impact, and the evidence on fault. And finally, if the claim involves serious injury, disputed liability, a long delay, or a release you are being pushed to sign, talk to a lawyer before you make the decision that cannot be undone. Legal problems are stressful, especially when you're trying to heal, work, pay bills, and make smart decisions at the same time. So if you've made it this far, you're already doing something right. You're educating yourself before the insurance company gets too far ahead of you. If you have questions, drop them in the comments and I'll try to cover them in a future video. If you want more straight, practical legal education every week, subscribe to the channel. And if you have a specific situation and need legal advice about your own case, reach out for a consultation. You do not have to figure this out alone, and the more informed you are, the harder it is for anyone to take advantage of you.